the UN Permanent Forum on Indigenous Issues in New York this last week. It ran for like 2 weeks, and it's an opportunity. And I don't know exactly how you get on the deck, so to speak, to speak at this thing. I've been there before, but really as more of a part of the press, both as a writer for the Truro Times at the time and for being a radio host. So I've never really spoken at this. I spoke at other events. August they do an event in at the UN also for World Indigenous Peoples Day, but this was they do this every year, and it can range from 2 to 3 weeks with folks giving testimony, and my concern, and I got to say this, and I can't speak specifically an absolute for sure, but as I have, seen, it doesn't appear that the doctrine of Christian discovery, the trust doctrine, or the plenary powers doctrine ever made it to the floor. And if I'm wrong, and I hope that I am, then perhaps somebody can reach out to me after the show or whatever. But here's the problem, and the problem is that we seem to be afraid to confront this. And there's a variety of reasons why we're afraid to confront these things. I mean, there are certain people, iconic native legal scholars and political scholars and that kind of stuff, who are so concerned if these three racist legal doctrines condemned by the United Nations, by the way, let me just say this right off the top. In 2007, when they passed the UN, they passed the UN Declaration on the Rights of Indigenous Peoples, the third affirmation clearly says that all doctrines, policies, and practices based on the superiority of a people's is racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Now, it stops short to say it's a war crime, and maybe that's the way we need to up the ante on this thing. But again, to be clear, the UN in General Assembly passed this. Only 4 countries voted against it. Of course, that was the United States, Canada, Australia, and New Zealand. But so this thing gets passed with, and this is the third affirmation. This is right in the preamble of the. This isn't even one of the articles. It just flat out says that if you've got policies and practices or legal doctrines that are casting up any peoples, but certainly because this is an Indigenous Rights Declaration, but if you're casting people as beneath you, and if you're going to characterize Native people as wards of the federal government for no other reason other than being Native, then that's exactly what that is. So there's no question that the United Nations in this declaration has condemned this and has called it legally invalid. Not just, scientifically false, legally invalid, racist. That's what they call it. But we're still afraid to confront it. And I got to tell you, I'm not the only person who does these kinds of analyses. I mean, we've got this film out, The Long Hope. I've talked about this film at length. The people who influenced me most to do the film are folks like Peter Derico, who is not just a lawyer, a civil rights attorney, but he was also or I think he may still be considered a professor of law at University of Massachusetts at Amherst. He has been a major influence. His book, Federal Anti-Indian Law, is one that really kind of pushed me over the top to put together this film, The Long Hope. Of course, Stephen Newcomb is the guy who taught us all about not just the doctrine of Christian discovery, but the whole, what they call the trilogy of Marshall cases that start in 1823 and go through for the next decade, essentially, where the doctrine of Christian discovery, the trust doctrine, and the plenary powers doctrine all came out of the legal dicta from the longest-serving Chief Justice of the Supreme Court, Chief Justice John Marshall. So we didn't know any of this stuff. I mean, and I'm not saying the information wasn't available, but until Stephen Newcomb really did the deep dive on this stuff and taught us all of this, and I mean all of us, none of us were speaking of this. And look, I don't blame anybody who may have sat on some sort of tribal council or chief's council or elected council, traditional council. I don't blame any of our people for not knowing this, because honestly, and we say this in our film, most of what was happening in Washington, in the courts, we were oblivious to it because frankly, we weren't often, most of the time, even though they were talking about us and legislating about us, We weren't in the room, and we wouldn't even hear about what the things that they passed, sometimes for months or years later. So these were echo chambers of white men, basically directing our lives unbeknownst to us. I mean, and the way that we were characterized in everything from merciless Indian savages in the Declaration of Independence to, again, to always being referred to as heathens or pagans, or savages throughout much of the, all the adjudication, all the law cases, and of course being called Indians. These are the labels, right? And this is the way we were characterized. But we weren't in the room. In fact, we weren't even allowed in the room. We didn't even have standing to be in the courtrooms. And to the extent that there were cases that we are mentioned in, we oftentimes weren't parties to it. We weren't allowed to be until fairly modern history. But I got to tell you, uh, Peter Derico just released an essay that, and I think it's a published essay, but it's also put up on Substack. For if you look for his entries and his submissions to Substack, you can find this one. And what it's essentially what he's talking about is, here's the title. It says Federal Anti-Indian Law: Why a Challenge to Christian Discovery Creates a Metaphysical Crisis for the U.S. And that's what he's talking about here. Now, for those of you who don't know what a metaphysical crisis is, it's this whole metaphysical is this whole notion of analyzing whether something is real or not. And oftentimes we create these false realities out of our own perception. And of course, we can name anything from economic theory to obviously religion. I mean, are any of these things real? Or are they only real because we've made them real? And of course, we do this with language too. And I talked about that on I think last week's show. I talked about language, where we create these things through labels. And then there seems to be this notion that these very labels, like calling us a tribe, for instance, were we ever a tribe? I mean, we certainly weren't ever Indians. And then this label gets put on us, and then boom, this is what we are. Well, not all of us necessarily agree. So there's a whole idea about the labels and the perception that man creates, and the almost this illusionary reality that comes from that. So, and that's essentially what Peter's talking about in his essay. What he's challenging is whether, again, I always use the expression the house of cards, whether if you challenge the doctrine of Christian discovery and the trust doctrine and the plenary powers doctrine, does it make everything else collapse? He even questions whether it would make the entire basis of property law crumble. Now, I don't know how much going backwards this kind of thing affects, but I know part of the reason to challenge this thing is to change what's happening in front of us. What are we facing? Because we're still being impacted by this stuff. So I suggested that what it would have been a great thing if somebody read his essay at the UN Permanent Forum. And I know nobody did. So one of the things I want to do here, I just want to read the abstract that he created for this essay. I'm not going to go through the whole essay, but I do want people to look it up, and I'll post it on my group pages as well. So on Facebook and like. So let me just read the abstract. And here's what Peter says about what the essay is. The legal doctrine of Christian discovery remains the foundation of the United States federal anti-Indian law, yet it is rarely challenged directly in litigation. This essay argues that confronting the doctrine poses not merely a legal challenge, but a metaphysical crisis for the United States itself. Through close analysis of the 19th century Marshall Trilogy, Johnson v. McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia, the essay demonstrates that federal Indian law is grounded in an explicit claim of Christian European land appropriation and a corresponding denial of indigenous sovereignty. This essay critiques common misreadings of these cases that treat dicta about native occupancy, guardianship, and trust as affirmations of indigenous rights. Indeed, it shows how such language functions rhetorically to obscure the doctrine's central purpose, legitimizing U.S. ownership of indigenous lands and plenary power over indigenous peoples. Situating Christian discovery within a broader jurisprudence framework, the essay argues that land appropriation is the primeval legal act from which U.S. property law, sovereignty, and territorial authority derive. And he goes on and he does a bit of a comparison to Brown versus the Board of Education and a case that we talk about in the film called the Teton case. And the reason that he compares these two is because it's the same court. These two rulings happen a year apart from each other. So this is what he says again in this abstract. By comparing Brown versus Board of Education with the Teton versus the United States, the essay highlights how the court embraced racial equality while reaffirming colonial domination. It concludes by urging litigators to directly challenge Christian discovery, arguing that an avoidance perpetuates a system of domination sustained by legal formalism and reformist rhetoric. So I guess what I wanted to say in addition to this, and again, this essay is pretty remarkable, and it should be read. Everybody should read this. But they don't just reaffirm colonial domination. And it isn't just when it comes to the Teton case, which is a case where they said, no, Congress can wipe out any of your land ownership, occupancy, and any of your resources without your permission and without compensation. That's what the Teton case was. So this court that was, being challenged by the racial discrimination associated with the case Brown versus the Board of Education seemed to fully embrace not just white supremacy, but more specifically, because in the Teton case, this isn't just about propping up white people. It's really about stomping down on Native people. So when we talk about racism, oftentimes what we talk about is about white supremacy. But white supremacy is about holding white people above everybody else. But the point that I try to make, and again, I'm not trying to get into an oppression Olympics debate here, but the point that I'm trying to make with these three legal doctrines that Peter Derico addresses in this essay is that they are specific to us. So it isn't just about elevating white people against everybody. It's about elevating government power, government authority, specifically over Native people. So it's about condemning Native people to an inferiority circumstance. So we are the ones that are being pushed down. It's not even so much about lifting up white people. It's about pushing down our people. So it creates not only Native inferiority, but it casts Native people, not just as wards of the federal government, but as a subclass of human existence. And when you read many of the cases, and Peter Derico addresses it in his essay, it begs the question, did the courts ever really acknowledge Native personhood? You see, I mean, we are afraid to sometimes get involved in this notion of being treated inhumanely or as non-humans, but there's no question that we're being treated at very least as a subclass of human existence. Some of the cases one of the cases that Derico cites there, we are specifically referred to in comparison to brute animals. So, I mean, there's no question that the United States, in their whole history, and everything from residential schools to the double dealing and dirty dealing in treaties and allotment and all this land appropriation, that we were treated wrong. And we were treated as less than human. We as a country that was priding itself in all of this notion of freedom and all men are created equal, we were never a part of that. We were obviously excluded from the U.S. Constitution, the Articles of Confederation, and right up until the 14th Amendment, we were still being treated as outside of it, which I was okay with, because that level of distinction, I think, was important to our existence. But somewhere along the line, even as we were not included as U.S. citizens or as a part of the U.S. population, we were increasingly being ruled over by the United States government through the courts. Again, these legal doctrines are coming out of the courts, not out of legislation. There's no law about doctrine of discovery. There's no law about, there's no legal establishment of the trust relationship. And in fact, I'm going to talk about that a little bit here. Because when people questioned, well, doesn't the United States have a responsibility under this so-called trust responsibility? The courts have said, no, they really don't. Because at the end of the day, it's not really a trust. Like, I mean, everybody thinks about a legal trust. And what a legal trust is, and I've talked about it on previous shows, is this framework that gets set up by somebody first with the power to create the trust, the grantor, where they know that there's a beneficiary that needs a certain amount of protection and supervision. So they appoint a trustee whose primary responsibility and fiduciary responsibility is to the benefit of that beneficiary or that ward. That's what a legal trust is. That's what a trust is in U.S. common law. And Sam Alito, in a case, back I think in 2011, involving the Hickory Apache, a mining dispute, made it very clear. Well, it's not really a trust. We fashion it a trust. We style it a trust, is what he said. But the trust relationship the United States has with Native people does not have the same fiduciary responsibilities as a trust in common law. I mean, he flat out says it. So it's not a trust. But he goes further. And I want to read some of what he said in his opinion. And what the ruling was in this case was whether the Hickory Apache could learn of the negotiations that had occurred between the United States and a mining company to do mining on Apache land. And the United States was arguing, no, that's lawyer-client privilege. And the Hickory Apache were saying, well, wait a second, aren't we the client if the United States is serving as our trustee? And so this is where this clarification or admission, I should say, by the U.S. Supreme Court. And Alito wrote the decision. He didn't just write an opinion that was a concurring or an opposing opinion. No, he wrote the decision. He said, no, it's not really a trust. It's not a trust in that way. We call it a trust relationship, but it's not a legally binding or release. There's no trust document. There's no agreement. To say that, and they even use words like they refer to it as a statutory trust. Well, it's not. There's no law. There was nothing ever established, because if you ask, well, let me see that trust agreement. There is none. This is just, again, one of their extravagant pretensions, right? They just kind of make it up. But let me read where Alito went further after he discussed the fact that it wasn't really a trust. He says, throughout the history of Indian trust relationship, we have recognized that the organization and management of the trust is a sovereign function subject to the plenary powers of Congress. So it's totally up to them. And it's not subject to any fiduciary responsibility to the wards or the beneficiary. And then they cite all these lines from various cases. Here's one from 1982. Again, it was another Hickory Apache case. The United States retains plenary authority to divest the tribes of any attributes of sovereignty. Now, keep in mind, all of the justices go along with this, including the three liberal justices. Yeah, Jackson, Sotomayor, Kagan. None of them oppose any of these things I'm going to read from all these cases throughout history, because this is what Sam Alito was citing as proof that it's not really a trust in that same way, and that they don't really have a responsibility to Native people. But let me go further. Yeah, he says, in another case, I think in 1978, U.S. versus Wheeler, says Congress has plenary authority to legislate for the Indian tribes in all matters, including their form of government. So, this is the court basically saying, now we can even dismantle your government. We can do whatever we want to you. Another case going back a little bit to 1921, Congress has plenary authority over the Indians in all of their tribal relations and full power to legislate concerning their tribal property. So again, in case you forgot, the word plenary means absolute authority. But it starts to get even a little worse than this. Back at the turn of the century, in 1903, plenary authority of tribal relations of the Indians has been exercised by Congress from the beginning. That's not true. And the power has always been deemed a political one, not subject to the control to be controlled by the judicial department of the government. Well, that's interesting. So, in other words, you can't challenge this thing in court. You can't challenge this alleged power, this ultimate power that they're claiming. The power existing, and this is another case in around the same time, 1902. The power existing in Congress to administer upon and guard the tribal property, and the power being political and administrative in its nature, the manner of its exercise is a question within the province of the legislative branch to determine, and not one for the courts. Again, so this is another case, a separate case around the same time, that is basically saying this is for Congress only, and it is not subject to scrutiny by the courts. So again, let me clear what this means. What this means is that the power that Congress has is unchallengeable. And we know that because it's even when it's been challenged fairly recently, back with the Indian Child Welfare Act case, they basically said, we're not even going to listen to your argument. With that family, that Brad Keene family that was arguing that it was a violation of this and a violation of that, they said, no. We don't even have to consider that. All this court has to do is acknowledge that Congress has power to do this. In fact, we would argue that the courts don't have any power because that's what the record has suggested. But it goes on. Because the Indian trust relationship represents an exercise of that authority, we have explained that the government has a real and direct interest in the guardianship it exercises over the Indians. So they have a direct interest. The interest is one which is vested in it as a sovereign, not us, in the federal government. This is especially so because the government has often structured the trust relationship to pursue its own policy goals. Let me say it again. It has structured the trust relationship to pursue its own policy goals. Thus, while the trust administration relates to the welfare of Indians, the maintenance of the limitations which Congress has prescribed as part of its plan of distribution is distinctly in the interest of the United States. So again, let me go back to what a real trust is. A real trust involves legal documents. It involves creating a legal framework, a trust agreement that is submitted to a court and signed off on, which details three things: who the grantor was and that they had the authority to create the trust, who the trustee is, and what the responsibilities are to the beneficiary or the ward. Now, to be clear, the United States served as the grantor, as the trustee, and as we see from Sam Alito, his decision, citing all of these other cases throughout the history, which no justices have really challenged, with the possible exception of Clarence Thomas, believe it or not. They said, no, it's the United States is the primary beneficiary. So we being cast as wards of the federal government, just based on their classification of us as a unfortunate race, somewhat, some subclass of human existence, that we aren't even the beneficiary. They don't even have to prioritize how any of the decisions they make affect us. They can pursue their policy goals. And this is the court saying it. So when I'm suggesting that this stuff needs to be challenged, because in every one of those cases that I was just writing, and that's all Sam Alito writing it. And he's writing it to bolster the position of the court and of Congress to do whatever they want to do, and that they are not responsible to us. We can't even ask what they're doing in our regard. I mean, that's the point here. And I once again have to get back to my proverbial, you can't make this stuff up. I say that knowing that they just made this stuff up. So I mean, at some point, the notion that the UN has cast these kinds of policies, these kinds of legal doctrines as racist, scientifically false, legally invalid, morally condemnable, socially unjust isn't enough. For one thing, the United Nations doesn't really have enforcement power for things like this. I mean, they do have some enforcement power. I mean, the United Nations can do some stuff, but there's nothing in place. They do this UN Permanent Forum thing every year, but it's really like just a session of people complaining and citing examples of abuse over and over and over again. And I'm not saying it doesn't have any value, but if it doesn't get outside that echo chamber, if the rest of us aren't understanding this, if we are understanding that we are not being treated as a distinct political entity, which we are, we're being treated with distinct legal classification. I mean, this idea that these doctrines, the doctrine of Christian discovery, the trust doctrine, and the plenary powers doctrine, they are only targeted towards us. And they still do impact us. These are cited every time a law is passed regarding Native people. They oftentimes have to either reaffirm that Congress has the power to create the law. And then when it's adjudicated, if there's any attempt to even adjudicate or challenge this stuff, we get back to this notion that says, oh, no, the courts were never set up to adjudicate the power of Congress relating to Native people. Then what the hell are they for? Because I got to tell you, I went to Washington back when the Obama administration was reconsidering the U.S. position on the UN Declaration on the Rights of Indigenous Peoples. That's what they had called a series of meetings. The State Department was sponsoring them. I went down for 2 days. One day where the federally recognized governing systems of the United States or native governments were allowed to speak, and we just kind of witnessed it. The next day was for the rest of us. It was the NGOs or the people, right? And on the second day, and this was held at the museum, the Native American Museum in Washington, D.C., and in their auditorium. So it was a large space, and they had all kinds of agencies up on the stage to field questions. And one of the things they kept reiterating, which was the fact that the United States voted against this thing in 2010. Now this is 2010, so this is only 3 years later. And they're saying, well, the reason they voted against it then was because there was some concern that it would change international law. And there's nothing in the UN Declaration on the Rights of Indigenous Peoples that isn't already affirmed in the UN Declaration on Human Rights. But again, there was a concern. But part of the concern had to do with this notion of what does the international community regard as self-determination versus what does the United States determine as self-determination. The United States says, well, when we say self-determination related to Native people, we only mean self-determination within the framework that we give them. We're not talking about self-determination in the same way that people could declare their independence or establish themselves or assert themselves as a nation state. No. We don't mean anything like that. And we don't mean that they can assert sovereignty over their own lands. None of that stuff. That was what the United States position was in opposing the UN Declaration on the Rights of Indigenous Peoples. But the other thing they kept getting said was that they were concerned that it would undermine or disrupt or somehow destroy the current remedy for conflicts that existed. And they kept saying this, the current remedy. And I said, what is this current remedy? And they said, well, it's our courts. No, it isn't. You've made it clear that when the courts created this fabrication of power for Congress with the plenary powers doctrine, you've made it clear in case after case after case that plenary powers can't be challenged in court. So how the hell are your courts some sort of remedy for a problem created by your courts in the first place and then excluded from your courts secondarily? I mean, it doesn't even make any sense. And that's what I raised. And of course, there was just a little bit of foot shuffling and no real answer there. I mean, this is the absurdity. And again, I know my good friend Peter Derico and Stephen Newcomb don't like it when I cite it as racist legal doctrine, but that's what the UN called it. They called it racist, scientifically false, legally invalid. And while I don't like to cast this simply as something that we throw the race card down, but if you've designated a group of people whose main common thread that ties all native people on this continent together is the fact that we predate Europeans being here. But if you're going to say that common thread is such that you're going to cast us all as wards, which to be clear means we're incompetent. The reason you create a trust for a beneficiary is because that beneficiary is somehow been regarded as incompetent or incapable of addressing their own concerns, even if it's only temporarily. Maybe it's because it's a child or somebody who's ill. So you appoint a trustee to oversee and to ensure that this beneficiary, this ward of the courts now in this situation, or ward of this trust agreement, is not being taken advantage of. But that's not what exists with the United States claim for a trust responsibility. They make it clear that they are the primary beneficiary. It is their policy goals that they pursue. And they fashioned this notion of a trust responsibility or a trust relationship just so they could assert control, not protect us. And in fact, anytime that there was, and there have been case after case where people say, yeah, but you have a trust responsibility to us. The court, case after case, the courts have said, well, it doesn't really specify that. Yes, there's a general notion that your welfare is, that we have to navigate this trust relationship so it relates to your welfare. But if we have a need for minerals on your territory, we're going to take it. If we have a need to eliminate your occupancy of a specific territory, or if we feel that it's necessary to change your structure of government, eliminate traditional government and create something that we can fashion that looks more like ours, including your courts, any type of law enforcement, which doesn't exist on all territories. But no, this is exactly what they've done here. And it's never about maintaining who we are. In fact, the whole notion of this stuff was designated a war crime back in 1913. They call it denationalization, the idea of stripping away our national character, our cultural character, stripping it away, ethnically cleansing it, and then imposing the U.S. national character upon us. I mean, I referred to that by declaring that we're U.S. citizens is that, but this entire framework is that. So while I agree with Peter Derico that the implications of challenging this stuff could be far-reaching, and he suggests that much of the world regards the ownership and the appropriation of property as the basis for not only property law, but law in general. So when he suggests that challenging this thing could be a metaphysical crisis for the United States, what he's saying, does it undermine their entire lawmaking ability? I know from a native standpoint, there are people who've said, well, you challenge that, you challenge plenary powers, and you've eliminated the entire USC 25, the entire chapter of U.S. law that they call Indian law. And it's not Indian law. It's, as Peter Derico calls it, it's laws about us. It's laws over us. It's not, there's nothing in any of that entire chapter of U.S. law that asserts our lawmaking. It's all about U.S. lawmaking. So, I mean, you can't be any more clear about what the intent of that chapter is. And so those who are saying, if you undermine the plenary powers doctrine and the trust doctrine and the doctrine of discovery, that you could wipe out that entire section, well, yeah, you probably could. And this is why I refer to all of this as a house of cards. So the question ends up being, should we just topple the whole thing? Should we collapse it? Or, and this is why you've heard it on the show before, or should we try to lift off a card here and there? Let's target where this use of the plenary powers doctrine, which is pervasive in every aspect of federal Indian law, what if we find the most abusive and we just lift it off? Think about income tax, for instance. When they passed the IRS code in I think 1913, but when they declared that we were U.S. citizens in 1925, it said, provided nothing in this law or in this act shall affect personal or tribal property. Well, what does that mean regarding taxes? What does it mean? And if we are U.S. citizens, what does it mean to everything from the treaties that were passed? First off, we have to accept that citizenship. We do have a say in this whole thing. And ironically, the courts fairly recently have upheld provisions of some of these treaties. So for all intents and purposes, if the courts, and there's a case out in Yakima territory, the Cougar Den case, they call it, where the Yakima Nation submitted an amicus brief in that, where they challenged the plenary powers doctrine and they asserted their treaty in defense of a fuel wholesaler, a native fuel wholesaler, who was being charged by the state of Washington for taxes. And Cougar Den won that case. And they won the case based on the courts acknowledging that the treaty was still valid. Well, then the question I have is, if the treaty is still valid, then you're recognizing that we aren't U.S. citizens. Let me say it again. First off, no country has treaties with its own citizenship. So if the courts have acknowledged in that Cougar Den case that the Yakima Treaty provided enough protection for this fuel wholesaler not to be taxed by the state, weren't they acknowledging that we aren't really U.S. citizens? Because you're acknowledging that this treaty still exists, and treaties only exist with two separate parties, the United States and the Yakima, the United States and the Six Nations, whomever. So, this is the fear that I have about too many people or every Native person accepting U.S. citizenship. Doesn't it essentially wipe out us as a party to these treaties? So, this is the challenge that exists. Now, if we challenge the IRS code, for instance, because we're saying, well, that's personal and that's property. If I'm selling my labor and I'm deriving an income for the sale of my labor, that very Citizenship Act that you declared us under says that nothing should affect our personal property. Well, isn't money in my pocket my personal property? Isn't it? So perhaps we challenge the veracity, the legitimacy of frankly, of the Indian Citizenship Act. Now, that doesn't mean that Native people can't be U.S. citizens. I'm not saying that. And in fact, I think the United States would be hard pressed. In fact, it would be a violation of the UN Declaration of the Rights of Indigenous Peoples if they denied our desire to be a U.S. citizen. But what if we don't? Because I go back and I ask the question, I've asked it on the show many times. What were we before they declared we were U.S. citizens? We were distinct. We were essentially free and independent people. Now, granted, we were in a constant state of conflict with the United States, so freedom wasn't granted to us by the United States. It was never a grant of freedom. It was never a grant of independence. It was an acknowledgement, and that's why they were trying to take it away. I think it was in the late 1871 when they passed an Appropriations Act where they said, we're no longer going to recognize Native people as independent nations. Yeah, they said that. We were at the table. Again, this was another example of their plenary powers. They could just make these declarations. Well, what changed? What did we do? And you could do this to every one of us, all of us, all those hundreds and hundreds of distinct, independent, free and independent nations. You could say, we're no longer going to recognize that you're free and independent. Now you are wards. We're going to formalize this notion that was already suggested 30 years earlier, that you are wards. You are captive. You are wards of the federal government. We're placing us as your trustee. You're not the primary beneficiary of this of this ward, this trust responsibility, but you're going to exist in the United States as a subclass of human beings, I guess. Although they never really come right out and say that. They never really call us human beings. They never call us. I mean, and in fact, it's interesting. One of the objections to the UN Declaration on the Rights of Indigenous Peoples was that last word, peoples. See, the United States had no problem recognizing that we were indigenous people, but they didn't want to recognize that we were peoples. I mean, that we were organized as groups. They wanted to make it sound like they dismantled all that we were mere descendants. And see, that's the problem that I have with the word indigenous. Oftentimes that word just means that we are descendants of a once free and independent people. And the United States opposition, direct arguing opposition against the use of the word peoples with an S, was proof enough that they were directly and diametrically opposed to this notion that we be treated as groups of indigenous peoples, that we existed in these larger groups rather than just being descendants. I mean, it's, again, you can't make this stuff up. But my question is, how do we go past calling these policies, doctrines, policies, and practices racist, scientifically false, and legally invalid? How do we get to the place where we say, no, they're not just invalid, they're criminal, that they are punishable war crimes? Because look, that's what genocide is, right? Genocide is a punishable war crime. Denationalization, coming out of the, at the like 1911, 1913, in that area, this denationalization was being bantered about as a war crime, a punishable war crime. The idea of ethnically cleansing a people. Well, what the hell do you think the United States did to Native people and is still doing to Native people? Every time they try to force their authority over us, they do it under the same banner: plenary powers, trust responsibility, and oftentimes they got to cite the doctrine of Christian discovery, like Ruth Bader Ginsburg did in 2005. She had to flat out say that under the doctrine of discovery, she left out Christian because maybe her Jewish faith wouldn't allow her, I don't know. Under the doctrine of discovery, title to the lands occupied by Native peoples, original peoples, became vested in the sovereign. They always referred to them as the sovereign and us as something less than that. And granted, I sometimes struggle with the word sovereignty and sovereign because it's about power, not about freedom. But that's what she said. It became vested in the sovereign. First, the discovering nations of Europe, then the colonies, and then the United States. She didn't say how it became that. She just says under this doctrine that she was basing her decision on, and all of these other decisions, this stripping away of our sovereignty, which is exactly what Peter Derico addresses in this essay. It's all based on this notion that once you've appropriated, once you've stolen and taken the land or declared that land, and of course, keep in mind, in that Johnson v. McIntosh case, Chief Justice John Marshall goes beyond this notion that we were merely discovered. He tries to equate, and he calls it an extravagant pretension of converting discovery of an inhabited lands into conquest over those lands and peoples. Yeah, that's what he did. And he said, but if you can get away with it, if you can do it and sustain that notion, of course, it's easy to sustain this notion that we've conquered if nobody ever told us. Nobody ever told us that we were the subject of conquest. No, they did all this stuff in their own echo chambers, as I said earlier. They do all this stuff within their halls of power, and we're not in the room. We're not in the room, and we don't even hear about it. Nobody's coming back and saying, hey, you know what they just said, what they did in Washington? They just said this. They just said, you are now citizens of the United States. When Lewis and Clark went on their expedition with a slave and with a native woman and went across all these territories, they said, well, just so you know, the United States now claims ownership of this land. Now, we weren't ignorant people. But this notion that these two white guys with a couple of people of color in tow or and trying to facilitate the conversations would suggest that some place that these people would have never been to or weren't even familiar with is now claiming ownership of the land that they're occupying. I mean, I don't know why they just didn't kill those suckers, to be honest with you. They should have. I mean, not that it wouldn't have kept the wave coming, but this notion that they would go out there and tell people this, and of course we thought they were nuts. I read some of this stuff today, and I still think they're nuts. I think it's crazy that Congress has the power to dismantle our governments. That's literally what they're saying in these cases. And not one justice, well, I'll take it back. I think Clarence Thomas is the only one who's questioned this power consistently, and he's been doing it for over 20 years. But he's just one guy. And I don't think his motives are that clear or altruistic either. But those three liberal justices, and going back to the queen of liberal justices, Ruth Bader Ginsburg, she cited the doctrine of Christian discovery in a case, in a ruling, in a decision she wrote, in an 8-1 decision against the Oneidas, one of our 6 nations. And and they say it has always been, we've never had title to our property. That's not true. Canandaigua Treaty says it 3 times, that the United States recognizes that the land is ours. Now, that may not even be our language, but it's the language that George Washington's representatives were suggesting, that the land is ours, the property is ours, and they will never claim the same. I'm doing the show from the Cattaraugus Territory of the Seneca Nation. This land is not part of the United States. It's surrounded by it. It's surrounded by New York State and the United States, but not just technically, legally, this land is not part of the United States. And again, there's case after case where they've said, well, this notion of independence is has long since gone. No, it hasn't. No, it hasn't. And their courts have supported this notion, supported Congress having ultimate and unchallengeable authority. Again, I gave you 2 examples where the courts have said, look, this is a power that Congress has, and it's not subject to the courts. Well, if it's not subject to the courts, who is it subject to? I mean, we've gone beyond just this notion of the plenary powers of Congress. We're talking about the plenary powers of the courts to create the plenary powers of Congress. The fact that the courts could create this ultimate authority and then remove themselves from oversight, I mean, it's just absolutely absurd. So I don't know. I don't know how we get this issue not just litigated, but I mean, we got to push this issue again in the United Nations. Every August, there is a day they call it the World Indigenous Peoples Day. It's usually like August 9th through 12th, or between August 9th and August 12th, depending on what day it falls on, I guess. World Indigenous Peoples Day. And I've been there. I have been there and raised issues. And my issues haven't been very welcome, let me tell you. They've never been that welcomed by the moderators or the panelists. Well, not all the panelists. I've gotten rave applause there from the people in the gallery, essentially. But it's high time that this notion of these racist legal doctrines, these invalid legal doctrines, that it goes beyond that and gets recharacterized by the international community as not just legally invalid, but unlawful, punishable. I mean, this is what genocide is built on. Not just, I mean, generally, you can't create genocide without having some absurd level of authority to do it. And the fact that the United States has maintained this since the early 1800s, and that the courts continue to support this. I mean, they call it settled law. And even now, even Sam Alito is uncomfortable with some of this stuff. He raised the question. He said, well, if there's a limit to that authority, I don't see where it is. You've got Neil Gorsuch questioning it. You've got Clarence Thomas has been questioning it since for almost 20, for over 20 years now. So when I hear somebody say, well, we better be careful, we may cause, like Peter says, a metaphysical crisis for the United States, or that we may wipe out an entire chapter of U.S. law. I'm saying, so what? Whether we bring it up or not, it is being discussed. There are justices, even without us raising this, and although it has been raised, interestingly enough, again, getting back to that Yakima case, they never addressed the amicus brief from the Yakima Nation challenging the doctrine of discovery. They only stood by the part of the brief that mentioned their treaty. Now, I'm not saying they didn't consider it, but they didn't raise it. Not even Clarence Thomas, not even the guy who has kind of set himself apart from the other justices. Not even Clarence Thomas took the bait and wrote perhaps a concurring opinion that was different than the one that ruled in favor of the Cougar Den. I just think that it's interesting. So anyway, I wanted to talk about this today because of the UN Permanent Forum having wrapped up last week, and that's why I decided it's time to bring this up. And of course, the timeliness of Peter Derico's essay. Again, I'll post it up on my Facebook group pages so you can find easy access to it. It's a read that's worth taking. Now, we can challenge some of the things, and in fact, Peter himself challenges himself in some of this. But he's saying it must be litigated, even if it causes a quote-unquote metaphysical crisis for the United States. So I want to thank you. I want to thank you for listening to the show. I want to thank you for joining me each week.